our fellow Americans? Are we reaping our harvest of grief? Have we built our house on sinking sand? Why are we being ugly Americans?
Welcome to today's show. This is CJ Holmes, founder of Homes for Justice, and your host for today's show. I believe it's a turning of the tide show. I've got with us a live guest that's going to be discussing a breakthrough federal court ruling. But before that, I want to just briefly bring a couple of things to your attention that are happening because, as you know, there is no such thing as a slow news day anymore. There are just amazing things afoot, and we need to keep up to speed on that. I'm only going to concentrate on 2 or 3 things on banks because today is a Bankageddon day. It may take another, few days to actually get the rulings recorded, that kind of thing, and our guest is going to explain all of that to us. And I've actually got a working document so that we can figure out how can we strategize, capitalize on this for everyone, not only in this country but throughout the world, because it's about securitization fraud and the claim that they have right to title on the property when they actually don't. So I'm super excited, and in just a minute we're going to welcome James to the show. First though, I just wanted to show you this little chart, get it on the comments links section. Too big to fail has already failed. It's over. Look at these. These are Wells Fargo. This is returns on their stock. Here's JP Morgan Chase. Oh, here's Bank of America. It was negative. And here's Citigroup. Remember yesterday, I think it was, I showed you the chart of how many trillions these banks had sucked out for themselves out of the Federal Reserve. And Citigroup was 2.5 trillion. So, of course, it's taken the most. It's failed the worst. This is the point. And then, of course, another fund sues over Fannie and Freddie. It is going to continue and it's going to ramp up. And the fact of the matter is, it's been a long fight, but truly the truth is coming out. The attorneys have learned how to correct the pleadings. The judges have started to learn what is really going on, and they're not happy. That is such a plus for us, the owners and the investors. And then, of course, here's another foreclosure case bombshell. Chase committed a fraud upon the court. Gee, what a shock. I'm so shocked. And as you and I, those of us that have been following the foreclosure fraud for years, sometimes a decade, this is absolutely no surprise. And just before I welcome James to the show, I want to point out, please go, and I put this in the email blast, but if you didn't get a blast, if you're watching this, go to the, and it's live, go to the website, greattransition.org, and here's the live chat. I've got live chat up on my screen. I will try to answer questions. Just type them in, and then during the discussion, I can bring them to our attention and see what James has to say about it. So without further ado, I'd like to introduce James McGuire. He's been fighting this for at least a decade. And James, I'd like you to do a couple of things to start. He's with us via Skype. I'd like him to briefly bring us up to date about why he is such an advocate. And then I'd like to start with the FBI information, which I also have, James. Welcome to the show. So let us know about what you've been doing.
Well, it's a lot of things that are going on in the background. I don't know everything that's going on. Don't want to know, don't need to know. It's kind of like Johnny Appleseed. Plant a seed, move on. Just make sure what you plant is right. And it takes time.
Yeah. So tell us what got you into this fight.
What got me into this fight was back in 2000. I knew I'd made my payments, and all of a sudden I'm facing issues, and I've got to where in my own personal, they added to my principal value on a lawsuit they lost. And the fight was on, and from then on, it's evolved to where it's even greater than that. Because if we don't bring humanity back on planet Earth, and we don't do what's necessary, then what's after this Earth? You're going to choose your path now. So the choice is yours.
Yes.
It's everybody's choice as to how they want to go.
And like I have on the screen, the choices that we make as adults will affect our future, will affect our children. It's very important that we battle. So tell us what you did in 2009 with the FBI.
2009, I sat there, and several years prior to that, it was already pretty well understood what they did was illegal. So in, I believe it was April of 2009, I put together a detail with specificity showing how the fraud was committed, and it was faxed to the FBI in Dallas. And 4 years later, they're still trying to figure it out.
Right. Well, we know that federal agencies often can't figure anything out. Look at the SEC, how they could never figure out Bernie Madoff was cheating, except they'd only been told like 8 or 10 times.
Well, I don't go into what the SEC is doing, and I don't keep track of all those types of crooks. There's so many crooks in the world. Everybody has taken up little certain areas, and we operate in that area. We plant the seeds and we move on, and we hope that people learn from it and advance from it.
Right.
Because if we can't bring humanity back to this planet, then we're all doomed to slavery, even our children. For these people that sit there and say, well, it doesn't affect me. It doesn't affect you now because you can't see past the hair on the end of your nose that your children or grandchildren are going to be in slavery, but you're going to be dead, so who cares?
Exactly. I totally agree. So bring us up to speed with the current ruling, the Nueces County versus MERSCORP and B of A. And then please go into the detail about the kind of law that was used. Let's start with the law first, if you will, because I personally am confused. So I'm sure a lot of people watching would be confused. Attorneys may not be, although some attorneys might be too. Can you bring us up to speed on that?
Okay, there's two scenarios that are playing when you deal with a mortgage contract. You're dealing with a promissory note and a security instrument. The promissory note falls under UCC. It's under equitable common law. The security instrument, since it affects, in almost all the states, affects real property interest, it falls under statutory law. If you sit there and so in essence you have statutory law attached to common law. So you go in and you argue before a judge, well, Your Honor, my note was this, or my note was that, or I don't know who's the proper person on the note and all that. You just walked into a court of equity and told the judge, I owe somebody, but you've never disputed that person doesn't have a legal claim to that title. You kept it in a court of equity with just, oh, I owe somebody, but I don't know who. Well, what's before this court is somebody that's claiming to be, and I don't have any other option other than to give it to the person that it claims to be. That's the closest thing I got to rule on. So you get your ass kicked in a heartbeat, because people can't separate equity from statutory law. That's what the opinion in Bandruff did. Everybody was watching Nade out of Oregon, but the one that was really critical was Bandruff. And in essence, it's in there. We don't care what the security contract says, or the mortgage, or the deed of trust, whatever label you want to have it. You can't contract around statutory law. But if you go to the note saying, well, Your Honor, there's a lien against my property, and this note holder hasn't proved it yet. Well, it's the closest thing I got. You lose. And people don't bring up the legal argument. They bring up the equitable argument. Drives
Right.
me nuts.
Right. So would this be a correct summary? They talk about the note versus about the applicability of the access to the title because of the securitization.
Well, you can talk about the note, but every time you talk about the note, you better bring up in tandem in the same conversation. There is a note. It's supposed, under statutory law, it's supposed to be secured by this security instrument. It is not. So yes, Your Honor, they may have a right to a monetary judgment, but they don't have right to real property. That's between the difference between equity and legal.
Oh, say that again. So actually,
You
because
have
there
to-
may be a note that may somehow be provable, that would be a monetary settlement, but not to the title and the property because they don't have.
Because you can't prove that the legal title is now remained lawfully, statutorily attached to the equitable claim on the note.
Now, this is what you've been talking about all along, from the tangible and intangible, right?
For years, and I know years ago I was labeled as a wingnut theorist because there's no case law. Well, people, the case law is now coming out. It
Yes.
just took years.
Yes. Yes, because there's so much confusion. Well, I believe it was intentional obfuscation on the part of the banks, and in creating the MERS device, if you will, that it was meant to utterly confuse and help them get away with this.
Absolutely, it was all designed to be so complex that nobody would ever think it would be de-engineered before they gotten so big
Right.
that they could not fail. But it happened in a time frame not what they expected. What should have taken 30 or 40 years was uncovered in less than 10.
So you're telling us that you feel from your experience and interaction that they expected we wouldn't figure this out for 30 years.
Correct, that's what I feel.
Right.
That it had been 30 or 40 years from the date they enacted it. By that time, well, our customs and procedures are so well established. Wait a minute. Go back to the Fifth Court of Appeals in 1988 in United States of America versus Hibernia Bank. We don't give a damn about your customs if law governs.
Right. All right. So basically, if I can summarize this, you and others working with you have taken your understanding of the difference between statutory law and equity or common law and created a lawsuit pleadings that were able to get the correct judge rulings.
Well, actually, that would be correct, but the Nueces County its order came out. It's just explaining precisely almost how Bandrup and Oregon Supreme Court, which was in response to federal questions, they're pretty well following the same patterns. But what that court did is when it entered that order for Nueces County the way it did, it's an interlocutory order because we presume that Nueces County is going to go back and amend their completing to get their cause of actions back in there, and they should do that under the criminal code.
Okay, now before we go on, James, explain to us what interlocutory means. I've got it up on the screen. What does that mean?
It's an interlocutory order. It depends on whether it's in the criminal or the civil environment, but it's not a final order. And if it's not a final order, it's not appealable. except in severe cases when it's usually in criminal, when habeas corpus or people are involved, the courts will look at an interlocutory.
Now, why do you think the court did this?
Well, that's where you have to look at the other suit that is going through this same court system, to the same court, to the same judge. It's dealing with Bank of America, just like the opinion came out, except this second argument that is going through is in absolute such specificity that the pro se that's handling it, he understands what's at stake, and he's pushing it all the way through to expose their crime, and he's doing in specificity. And I have reasons to believe this interlocutory order came out saying, hey, we understand. Your arguments are fine. Bring it on. Because in this case of Joy Rodriguez versus Bank of America, Countrywide, and Recon Trust, it's asking that, hey, these people are claiming title to real property, but under the statutory law, they don't have a right to it. Tell them go away.
Now, I have up on the screen what you sent me. This is an order, but it doesn't look like it's been issued yet. When is that going to be issued?
That is the proposed order that's been submitted to the court, that as of this coming Monday, that is the declaratory request that the pro se is asking for.
So Joe is asking for them to actually rule that they do not have a legal claim to title.
That the defendants in that case do not have legal claim to title. We're not saying, he's not saying somebody somewhere's got a note may have legal claim. He's just saying these people don't.
Exactly. Countrywide, Home Loan Servicing, Bank of America as successor by merger to BAC Home Loan Servicing, and Recon Trust.
Now that all ties into what came out in the interlocutory order in Nueces County, and pretty well follows what's taking place in the Oregon Supreme Court in their answer to federal questions in Bandrup.
Okay, so here's Bandrup, and this was done June 16, 2013, this article that I've got up on the screen. Can you just break it down for us, summarize this, and then we're going to go through the Nueces County interlocutory ruling.
The Bandrup article pretty well explains it. Whoever wrote it, I don't know who wrote it, where it came from, but it's in my opinion, it's very extremely precise.
MERS dressed in sheep's clothing is still a wolf.
The wolf is wolf, regardless of how you dye the fur.
Yes, a final word on MERS as beneficiary. And see, I've been talking about this over and over and over because I'm looking at the recorded documents. People will say, help me. So I will get the document. I will look at the deed of trust. And in my worksheet on my, analyzing your recorded documents, little foreclosure or do-it-yourself defense, I will have N and B, a small N and a big B, because in the same paragraph, the first sentence says MERS is a nominee for this lender, whatever it might be, and then the next sentence says MERS is beneficiary, and I have referred to that as calling MERS in that paragraph. They're either a lion or a lamb. How can you have the same those two different animals as the same entity? And this is a final word on MERS as beneficiary, because this is basically, correct me if I'm wrong, James, this is basically what is being ruled against. MERS is not a beneficiary. The gray old MERS, she ain't what she claimed to be. MERS is not and never has been a beneficiary under Oregon law. I've heard other attorneys and people say just because they say so doesn't make it so. And so you have to prove beneficial rights and standing under the law. Now that would be statutory law, right, James?
Yes. Now, if you go back to what you just said about beneficiary, if you look on page 3 of that Nueces opinion, it says, MERS may have the right to foreclose on the property as an agent or nominee. Not beneficiary.
Right.
They're just a freaking agent if you can prove agency relationship.
Right, right. Now that is a whole nother discovery challenge in itself, correct?
Correct. And now you're starting to get over into the equitable side of law.
So agent or nominee, that would be the equity side, not the
Right.
statutory
That would be
side.
the lender side for the note.
Right. Okay, let's start at the beginning of the Nueces ruling. It says the court concludes that plaintiff, in this case the county, alleged sufficient facts to give rise to a plausible claim for relief with regard to their causes of action, alleging the violations of this section of the Texas Civil Practice and Code, unjust enrichment and fraudulent misrepresentation. The court retains those causes of action. I love that, fraudulent misrepresentation, because I believe that correctly describes what they've been doing. So with regard to plaintiff's conspiracy cause, the court grants plaintiff leave to file an amended complaint asserting additional allegations demonstrating a conspiracy among defendants within 14 days. So I'm guessing out loud, James, that this is why the judge ruled an interlocutory.
I think it's a warning to everybody that we're coming. There's nothing alive that's going to stop us. We are coming. We know the truth.
Right. It's only taken us 10 years, but we've finally gotten it figured out, and figured out in court. Right?
Correct. And proving the conspiracy, it goes back to, I think it's MDL pleading 2132, which is multi-district litigation, and this was Judge Teelberg in Arizona, who in a court transcript said, "You bring me the right argument, the right names, and regardless of the harm, we'll do something." I, for over a decade, have watched so many people don't know what they're writing. I mean, when they write a QWR, or they write a discovery as to who's the note holder, you're making an equitable admission. You're going to get your ass kicked in an equitable court of law. You've got to get it to where it's not the note that's at issue. They're going after the alternate mechanism to collect on the note, which is under statutory law, which has been violated. It's no longer available.
Okay, so explain that, James. We hear your words. Say it to us again in ways that can be understood. So I've got up right now on the screen, page 2, the MERS electronic mortgage tracking system was created by members of the mortgage banking industry, including defendant Bank of America. You had that highlighted. And then on the next page, we've already talked about that MERS may have the right to foreclose as an agent or nominee. And I would like to continue this. You didn't highlight this, but it says, however, MERS has no interest in any proceeds from a foreclosure sale. So they don't have any harm. Is that what that basically you're saying there? They can't take the money from MERS doesn't get the money. It's some bank that gets the money.
Well, but the suits that I see here is like Bank of America as trustee for somebody.
Right.
It's not really, MERS hasn't really been named as a principal party in a long time.
Right. And so this just talks about MERS has no beneficial interest in the loans that they've registered. It's merely that of an agent or nominee of the members.
Right. It's another way for the court saying they're not the beneficiary.
Right. Right. So let's continue. You highlighted, this is page 6, the court's objective in construing a statute. Can you continue the explanation of this?
Well, I had to get down to it. I kind of ran past it. I'm just about there.
Okay.
Well, you look at the second sentence, to determine intent. By everything that's been done, you can see that it was intentionally done. So under criminal law in Texas, it's under Criminal Code 6.1, is culpability. What was the state of mind? What was the intent? The intent was to sit there and suck up the money, which the repercussions were committing fraud. So there's intent there.
I see what you mean. Yes, so there's intent. That is very important. Now I've got the next page up, page 7. Numerous Texas courts have also recognized that naming MERS as the mortgagee in a deed of trust so that it may serve as the nominee is permissible under Texas law. And I have a lot of rulings from a lot of different states that basically say the same thing.
Yeah, I don't have a problem. They can serve as the mortgagee, as the nominee, or an agent, but you can't contract around statutory law. Plus, in a lot of these security instruments, if you get into Covenant 20, you're going to see that they're going to sell the note or an interest in the note along with this security instrument. That's your secondary market intangible. That's fraud. You can't contract a contract to commit fraud. It's illegal. It's void.
So using MERS as a nominee is not illegal, but doing what they were doing with it is not legal.
Correct.
See, now we're splitting the hairs that needed to be split. And that's why we get all of these rulings saying, well, there's nothing wrong with using MERS as a nominee or an agent of the lender.
Yeah, it's like the last sentence on page 7 and the first sentence on page 8.
Yeah.
Accordingly, the court concludes that under Texas law, it is not fraudulent for the lenders to designate MERS as a mortgagee in a deed of trust for the purpose of MERS serving as agent or nominee. I don't have any problems with that.
Right. See, it's the wrong argument, the wrong pleading, the wrong thing to take to court to get the rulings that we've been wanting. Now, you have highlighted on page 8 and highlighted in red, however, just merely designating MERS as a mortgagee to act as an agent or nominee of the members does not make it a lender.
Right.
So MERS cannot enforce, doesn't have the rights of the lender to enforce a promissory note and seek a judgment against a debtor.
Correct. MERS doesn't, as a lender or a beneficiary. MERS is as an agent for the lender or the beneficiary might be able to.
So how does this, most of the recorded documents that I see with MERS on them now, and I have not looked at those in 2008, 9, and 10, but more lately because people are actively trying to stave off foreclosure. So those tend to be the documents I find. It typically, MERS, as the nominee, assigns beneficial rights all over the place. Illegally most of the time because they assign.
What beneficial rights does MERS have? None.
In other words, how can they assign beneficial rights?
MERS can't assign beneficial rights. MERS as an agent for a lender might be able to, but it's not specified.
What would it look like if it was specified?
MERS as, they're pretty close to covering it. MERS as nominee for successors and assigns, identified as whoever. But MERS stops at successors and assigns. There's no proof that there is an agency relationship.
Do you know how to prove agency relationship? How that would be proven? I've heard this before, and I'm not sure what it would take to prove agency relationship.
Well, agency relationship. Now you're going to pull in equitable arguments of the note together with legal arguments to title.
And so why bother is what I'm hearing you say.
Okay. No. Okay. There is a point. You have to argue them in tandem to be able to prove there is no agency. Because now you've got to shift back to the note. And I know, and a lot of people, there's a lot of continuing legal education courses and a lot of attorneys that will argue on the endorsement on the note, paid to the order of an unidentified blank creates a bearer instrument. There is federal case law and multiple case law from numerous jurisdictions that says paid to the order of an unidentified blank is an incomplete instrument. It does not create a bearer instrument. At that point, as long as you've got an unidentified there and it's negotiated, or they claim that it's been negotiated multiple times without identifying the intervening parties, your chain of agency breaks down.
Right, right. And then, so you address that, but continue to push on the statutory law. In other words, do they have right to title on the property?
No, because they lost it on the note side. They lost the attachment. The equitable note lost the attachment of the legal title because they didn't follow statutory law.
Okay, and can you say specifically how they didn't follow statutory law?
Well, if you look into Fannie Mae and Freddie Mac and a lot of securitizations, they require the PSAs, which a lot of people can't get into court, state that we're going to purchase the note and we need it with all intervening assignments of record and a final assignment in blank in recordable form, which suggests that their intent is, once they receive it, to perfect their interest in public records. If you don't perfect your interest, you're taking something at risk. You just may lose your rights.
Exactly. The people do. If we don't perfect our interests, we lose our rights.
Yeah, and trying to get it correctly is not that easy to do. I don't know if that answered your question or not.
Well, I feel like I'm treading in territory. I'm not real sure what I'm asking. I'm trying to understand. You know, I grasp. We've had you and Joe on the show before, and you've talked about the tangible and intangible, which is basically now we're talking about equitable and statutory law that apply to these different pieces of these notes and collateral, and they've split them apart, and the notes are covered under the equitable or common law, which would be the UCC code, right?
Under equitable, yes.
And then but the actual claim to the title of the property, which allows them to foreclose, is under statutory law.
Correct.
And they cannot prove that they have that right.
Correct. So if you go to page 14 of that opinion, MERS does not, however, hold any beneficial interest in the deed of trust. It is not a beneficiary of the deed of trust. It is merely an agent or nominee of the beneficiary. Okay, who's the beneficiary if the note's been negotiated in an incomplete instrument form? Who are they an agent for? It's unidentified. You lost your agency.
Right, you can't have a blank agency. And that does make sense to me. Exactly. In other words, like you said, this is a pretty sophisticated scam that they didn't expect us to figure out, particularly in a court of law.
Correct.
Soon enough to make any difference whatsoever. And we've already experienced horrific damage. Just talk to the 4 million people that lost their home to fraudulent foreclosure. And I am now totally accurate in calling it a fraudulent foreclosure.
Okay, now if we continue on to page 15, if the MERS system did not exist, MERS members would refile their deed of trust with the proper county each time the security instruments are transferred in order to remain perfected.
Right.
I mean, that's just the court's own words. I couldn't have said it any better than that. To remain perfected.
Right. And of course we've talked about what typically has been happening is that the the note is sold back and forth, and then they strip the payment stream out of that note and they point it to a mortgage-backed security, a trust, an investment on Wall Street, and yet they never assigned, they never did any of the paperwork that's required to perfect the security instrument.
You know, it's real simple. Also, look at a deed when they put a vendor's lien with it. I'm sure you've seen those, CJ. A warranty deed or a deed of some type with a vendor's lien.
Right, like a mechanic's lien.
Yeah.
Yeah.
But who's that vendor lien secure? The seller.
Uh-oh. Just a minute, James. Hopefully we'll get him back. There was a problem with his computer. Here, I'm going to hang up. I'm going to call him back. And truly, while we're waiting for the call to get connected again, the whole point, we can more easily understand it in something like a mechanic's lien. The mechanic's lien. Hey, James, you back?
Yeah, I'm back.
Okay, all right. I was just sharing, you know, it's sometimes so much plainer to think about something that we understand like cars. Like, you will, so, or a mechanic's lien. So if a mechanic does some work, you know, a contractor does some work on the house and the owner doesn't pay him, he can file a lien on the property to get paid. And that's what you were going to share with us, right, James?
Correct. That's what's occurring with a deed when a home buyer goes and buys it from a seller. A lot of times he gets it with a deed with a vendor's lien. Now, as soon as the seller is paid, before the seller is paid at closing, usually
Right.
that seller assigns his lien rights to the bank. Now, he's just sit there and hopefully the banks will not screw him out of the money because he just assigned his legal rights if he doesn't get paid.
Right.
And, well, I mean, I don't see that really happening because the banks are really going to get the money to the seller because that's usually to another lender. It's refinanced or something.
Right. Generally, those liens are paid off at escrow, you know, and then the net proceeds go to the seller.
And and as soon as that is done, the lien is discharged. It's technically discharged. It's now
Right.
void. It's
Right.
nullity.
Right.
So now you go and look at some of this paperwork that they present to the investors that buy these securities and so forth. Oh, we also have another alternate method. We have a lien with a vendor's lien assigned to us. It's assigned a nullity. It's another lie of the banks.
Well, they just have learned that by lying, they get more money.
Yeah, I guess if you tell enough lies, somebody's going to finally believe it's the truth, and I guess enough hedge fund people and all of them have believed it's the truth.
Well, I do know that really experienced securities attorneys, they've been confused also. The pooling and servicing agreements are written intentionally to be not understood. That's what I've heard.
I didn't have any problems in understanding. I thought they were pretty simple. A hell of a lot easier than an engineering design.
Okay, now I'm looking at page 16, and it says here, these are the judge's words, right? The judge wrote this?
Yes, judge wrote it.
I love it. And so accordingly, based on all of this everything that's been set up to this date, which is now we're on page 16, accordingly, one can reasonably infer from the allegations set forth from the defendants that from the plaintiff that the defendants were aware of the harmful effects the fraudulent liens would have on the county, and this is sufficient to establish intent.
So it's the same mentality, fraudulent lien against the homeowner.
Right.
It's still the same degree of intent.
Right. It's as if, James, if you and I just decided we were going to scam people, and we just filed millions of mechanics liens on people's property for which we did no work, and then they were stuck. They had to pay us at close.
You and I'd be in jail in 30 days.
Or faster. I know. And here they've filed millions and millions and millions of fraudulent liens. Not just in this county, but all over the world. People in South Africa, people in Ireland, people everywhere are fighting this fraudulent foreclosures, these fraudulent liens in the securitization Ponzi scheme.
Correct. I mean, it's global.
I know.
And if, like I said, if people think it's just going to affect them, wrong. If it's not addressed now and it's allowed to perpetrate, your children, your grandchildren are going to pay a price greater than what we have today. And all of these neighbors that are going, well, this not bothering me, their children are going to be paying a price. And they're going to, somewhere in the future, they're going to lose their retirements for bailing their kids out, trying to get them out of slavery that they should have already taken care of.
Well, here's another thing too, James, and this is even sooner than the kids, and that is when the judge uses in this ruling the term fraudulent lien, that there is absolutely no question left, there cannot be any question left in anybody's mind that all of these foreclosures for which they have stolen the houses without legal rights to do so, using fraudulent liens, and now the banks have taken those back. Like I even mentioned yesterday, everything they do is fraudulent, so they're not even accurate in doing credit bids at the auctions, which they've done on millions and millions of homes. They just take them back as if they own the loans when they don't, and it's all based on a fraudulent lien on the house. Then they take these back. They've already sold them. Some of these houses, James, have been sold 2 or 3 times since foreclosure, and so the underlying foundation, if you will, of that ownership is fraud. And all of the statutes in all of the states, probably in the world, say that anything based on fraud is void. Wouldn't that be a pretty accurate statement?
Yes.
So, and I already have people contacting me. I lost my home in 2008, and I'm sure it was fraud. And of course, I look at their documents. We can tell it is. It was a securitized loan, and it's. But the fact is the home has now been sold and resold. So what's that gonna bring to the table?
Well, some states will allow, depending on redemption and whether the order is void or not in redemption. And my advice is, if you're dealing with 2 or 3 people on the house later on, and it's people, not investment companies, leave the people alone, take the money, and go start over again.
Okay, now take the money. Where are you talking about this money coming from?
Hopefully the banks will have enough money when they start, but I doubt it.
Well, banks are going bankrupt. We already know that. We've already seen the little signs of, B of A and Citigroup. They're going to be failing, and discussions. I showed that, I think, last Friday, a little article about discussions with Wells and Chase to absorb B of A and Citigroup. Now, here's this, of course, this ruling brings to mind a humongous question, and that is, would anyone want to touch B of A with this kind of a ruling?
What do you mean by touching B of A?
Absorbing their loans and liabilities.
Well, I hear from rumors just in standard media that I thought it was Wells Fargo and Citigroup was looking at taking over B of A.
But do you think they would with this ruling?
Well, this ruling probably is going to affect them all, especially if the subsequent case that's in Corpus Christi Federal right now is ruled on, which could occur in like 4 or 5 days.
You're talking now about Joey's ruling?
Right. That could take place in 4 or 5 days. That's when when it first becomes eligible. How fast the judge is going to do it and what the judge is going to do, don't really know, but all the facts are there. The opinion in Nueces roughly tells us how she's going to rule, because she can't go against precedents that's already been set in the courts.
Right.
Considering she set the precedents.
Right. And it complies with that other ruling that you talked about, the Brandrup in Oregon Supreme Court.
Right.
So the federal courts are basically coming to the legal conclusion that the banks, if you will, I'm just going to use the word banks, as servicers, they don't have legal standing to foreclose.
They don't. They have legal standing to foreclose. Foreclose against what? I mean, people don't realize when they sit there and say, "Well, they're going to foreclose." I see that as an admission. What you're looking at, they have a right to foreclose. They don't have a right to go steal property.
Like you said, a money judgment, something against for the note, but not to take the property.
The property, the property being the ultimate means to collect, when they didn't follow statutory law to maintain that contract, is gone.
Right, right.
But a lot of people will go, well, they're foreclosing, and they don't bring up the title argument, or the judge don't want to hear it, or whatever. They're in equity, and they, well, Your Honor, it's an unlawful foreclosure. I see that as an admission that you're going to stay in a court of equity. You never even get to a court of law, and you're going to get your ass kicked.
Right. Right. See, this is, again, a real stretch for most people, because first off, they don't understand the differences. I've got it up on the screen again, the equity and the statutory laws.
They're not one and the same. They're different.
And James, you go into the same court, but it's the pleadings that you use, what law they are based on, is what determines
whether you're in a court of equity or you're in a court of civil law.
Right.
It's like Alvin Campbell's got a word name for it. Word crafting.
Yes, yes. Pleading crafting. Right. Right. Okay, so let's finish the Nueces County.
All right.
Now, I'm here on page, I think, 20, to require plaintiff to plead specifics for each of the alleged fraudulent filings in the case at hand would obliterate the Federal Rule's basic pleading philosophy. Plaintiff has stated sufficient facts upon which defendants can prepare an effective response and defense to all of plaintiff's allegations.
You know, this is where I say sometimes it's better to put all your cards on the table. Holding this stuff at the vest sometimes is going to defeat you.
So what do you mean when you make that statement?
Well, in this situation, they had to unload everything before the county had to unload all the facts to the federal court to prove beyond specificity. They weren't holding anything back. If they tried to hold something in reserve, well, we'll use this as our ace in the hole.
Right.
A lot of times that's going to defeat you.
Right. Because the defendant would somehow get a motion to dismiss, and then you'd never be able to use that? Is that why?
Well, in federal court, if the banks get a motion to dismiss, you've got to look at the federal rules. That's the same as dismissed on merits. Now you're blocked by res judicata and collateral estoppel and ever bringing it up again.
Right, right. But here, the defendant's motion to dismiss is denied.
Right. They're going to trial.
Now, here I'm on page 21. The court must first consider whether Section 51 blah permits MERS to serve as a secured party for a mortgage. In subsection B1, the court concluded that for purposes of Chapter 51 of the Texas Property Code, MERS is not a lender, grantee, beneficiary, owner, or holder of the security instruments, merely a nominee.
Right.
Now, it goes on to say that the court rejects defendants' argument that they are shielded from liability.
They are liable.
Liable for what?
The damage caused.
Now, this is from the county. So what kind of damages are they claiming?
$10,000 for each instrument unlawfully filed. That's a statutory penalty. $10,000 for each instrument.
And a court, I'm on now page 22 on your highlighting. MERS may serve as the nominee, but this does not make MERS a secured party. The security instruments secure the repayment of the loans to the lenders, not to MERS, has
Correct.
no right to enforce a promissory note or seek judgments against borrowers in default.
I mean, this is more getting it down to specifically what MERS is and is not.
Not. Exactly. And the court rejects the defendant's other arguments that there were no false statements because the borrowers agreed in the deeds of trust that MERS was a beneficiary and MERS holds a lien on the property secured by the deeds of trust. These arguments directly conflict with the language of the deeds of trust as well as Section 51, which state that MERS serves solely as the nominee for the secured party. MERS is not a lien holder, grantee, secured party, or beneficiary.
That's where you go back. You can't contract around statutory law.
Right. Just because it said so in the deeds of trust and 72 million people were forced to sign that to get the money to buy a property or to refi.
They didn't know any better to sign it because you got a stack of papers there. Do you carry a PhD in real estate law to know what every covenant and every line is?
And
no, they don't. Even attorneys don't.
And James, besides, what are they going to do? Can you negotiate these boilerplate documents with a lender? You can't do that. They just say, fine, we'll just give it to somebody else. You know, screw you.
That's it.
So we, the borrowers, the people, have no recourse. We have no leverage, no recourse, no way to negotiate anything in or out of those loan documents. We still don't. So now here, what is so good about this is that because the court actually said, you know, you can say that MERS has halos, doesn't make it so. And they're looking at statutory laws saying, according to the statutory law of our state, which would have to be like the rest of the states, right, James?
Pretty much so.
Yeah, maybe a different number, but the concepts are all similar, and that is MERS is not a secured party or beneficiary, and as such could not give beneficial rights, correct?
Correct.
Only as an agent of a beneficiary could, but they never, whenever you look at any of these documents, it never says MERS, well, it says the nominee. It says as nominee, they're going to give beneficial rights. That's why these things are fake.
You need to go to the end of page 24 and the beginning of page 25.
Okay, here we are. The filing of fraudulent liens undermines the reliability of the public record system on which so many rely, including landowners, purchasers, local governments, title companies, insurers, and realtors. Defendants' filings of inaccurate or fraudulent property records is alleged to be so widespread and pervasive as to have damaged the integrity of Texas real property records and to have all but collapsed the real property recording system in the county. If these assertions are are correct. The county has been harmed. First, because it relies on accurate property records in conducting its own business. And second, because the value of this essential public service and the county's value as an institution has been damaged if people and businesses can no longer rely on the accuracy of the property records it maintains.
And we're fixing to prove it.
Absolutely, absolutely. And this is basically the summary, the 25 words or less of what John O'Brien, as Registrar of Deeds over in Massachusetts, has been, trying to get the news media to pay attention to. They actually filed $1 million damages in the action against Lorraine Brown. And I don't know what they've gotten yet. And I keep asking, where's the ruling? Have you gotten anything yet? And they keep emailing back, no, we don't have it yet. We'll send it to you as soon as we get it. We'll let you know. And so they asked for $1 million from that Lorraine Brown judgment. She's now 5 years in prison. She was the founder of DocX, had pleaded guilty to mail fraud, wire fraud for creating 1 million forged foreclosure documents, sending them through the mail and the wire, and recording them on people's property. And of course, the $64 trillion question is that damage to the owners going to get undone? And so O'Brien has actually scanned all of their records in their county and knew exactly how many records had been sent by DocX, and requested restitution, accurate records, plus a securitization audit for each one to make sure they were accurate. And yet they know that it can't be done. And this is the judgment, right? This is the ruling that says it is impossible. It will always be impossible to ever create any legal document that would have the right to take the property.
Well,
is that correct?
That's the way I see it.
Yep.
And I see a lot of federal things going on in the background just by watching what's going on in the courts and the news. Nothing specific. But if you can think like the crooks as to how you're going to defraud everybody, you can see it's collapsing on them.
Yes, yes. And this I would call a milestone in the shift of legal ruling and opinion, because you can't get around the statements that are said here. I mean, it is point blank that these are fraudulent misrepresentations. Now, they point out, I'm on page 26, to maintain its property records, the county instead relies on those filing a lien or security interest with the county to truthfully and accurately represent the party's interests. And although the county clerk may file and index these security instruments presented for recordation, the county still relies on the truthfulness and accuracy of the documents presented for filing to perform its duties. Accordingly, considering the allegations of the plaintiff in light most favorable to the plaintiff, the court concludes that the facts set forth sufficiently from which one could plausibly infer that the plaintiff justifiably and reasonably relied on defendants' alleged misrepresentations. Absolutely.
This is where you get into criminal law, because under the criminal statutes, they have a duty to make sure that that instrument is eligible for recordation, and it's a criminal offense if it's not.
Now, James, just as an aside, your comment just raised a question. But criminal law, people can't go after the banks criminally, right? Doesn't that have to be our district attorney or Department of Justice?
Yeah, but in this scenario, we're fixing to prove they're crooks, then go take it to the cops and go arrest them because we've already proven them guilty.
Right. See, that's been the trouble. We, over the months, a lot of my contacts have, we've contacted district attorneys. They're just getting blown off, strong arm, just like, we don't want to talk about it. We don't want to, the DAs or even the attorney generals, and obviously you can't get Eric Holder, who's on the side of the banks, to do anything for the correct and legal for the people. So So we've been trying to get them to file charges. Now, would you think that this ruling would help efforts everywhere going to the DA? Should we take this to our DA and our forged documents and say, look, file charges?
This ruling won't get you there, but the one subsequent to that that's pending here in a few days will.
Okay, now that's this one, Joey's?
That would be the Joey Rodriguez that's upcoming.
Okay, and so you're going to keep us updated on that. And so you're expecting, this is what the order is the order of this court that defendants under contractual obligations subject to this suit, defendants have not made a legal claim, to title of real property.
That's the pro se's
Right.
order that he wants the court to, do they have a right or do they not have a right?
Right.
Sign it.
Right. And so let's assume that the judge will say they do not have a legal claim. So
then we have proven theft, attempted theft of real property. We're going to take the substitute trustee's deed and their actions before the county court to evict. We're going to use that information and go after attempted theft, because here's the prima facie proof, here are the names, and here's a federal order that says they didn't have a right to do it. Here's where they tried to do it in the county court. Go arrest them. We've already proved it.
now, could people in California, Florida, Georgia, could they take this order to their DA and have be given some time of day? Do you think?
I think if they got an order approved in their jurisdiction that states that there was no legal claim to title and there was an eviction involved, I think with that order that there was no claim to title, if you proved attempted theft of real property or theft of real property.
Now, you're saying, though, that this excuse me, this specific order wouldn't necessarily help people in other places, either in the state or in the, even though it's a federal court. Could people in California use this?
Well, they could use the procedures that it used to get there.
To get there, right. Okay, so once we have this order, you're going to share with us that lawsuit so that we can review those claims, so that people can basically copy paste.
Well, you've got the order there. It gives you the cause number. It's public domain.
Okay.
It's record court documents. Anybody can go get it. And they will find that it was removed from state court. The banks removed it from state court to federal. And oops, that was a mistake for them, because that allowed Joey to take it from going from being a defensive posture to an offensive posture, and he just will not back off.
Thank God. Thank God. We need fighters that will not back off.
Federal is, in my opinion, is a lot easier, but it requires a lot more specificity, a lot more knowledge when you walk in, and you don't have the time, because the federal courts aren't going to give you time, because it moves so fast.
Right. So back to the county's case. Based on the above allegations, the court concludes that the facts set forth sufficiently to give rise to plausible inference that defendants acted with the intent and purpose to induce the county clerk to rely on defendants' false statements regarding MERS status with respect to the security instrument, so that MERS would be recorded as the grantee in the county's property records, and defendants could avoid recording subsequent mortgage assignments and transfers with the county. So
Yep.
So the court is not going to dismiss plaintiff's fraudulent misrepresentation cause of action.
Nope.
That is huge. This is huge. I really believe this is tide turning. So in other words, other counties could take this kind of the pleadings and sort of copy paste for them, right?
Well, yes, and even more so would be the ruling that has the potential coming out on Monday in Joy's case. If the court's already ruled that they don't have claim to title, wait a minute, now the counties have even something even further. They can prove that Bank of America's use of MERS does not give claim to title. What more do they need to prove?
Here's a question. Can the, let's say a county in California, can they cite this Texas federal ruling in their lawsuit?
I think in federal they stand a better chance in federal. And I don't know I don't know how federal handle operates for judicial notice in California. I can't answer that one.
Okay, but I'm sure that there's somebody going to watch this that can answer that and will tell us. Because if that's the case, then basically it's truly a relatively straightforward matter to quote this ruling and get these rulings yourself in your own federal court lawsuit. The counties could.
Yeah, and I'm somewhat familiar with a lot of the California statutes. Substitute some of the Texas statutes with California statutes, and
Exactly.
You're probably there.
Exactly. That's what I was basically thinking. Whether it's California or Georgia or Florida, I mean, you can look at the statutes, you can read what they are in Texas property code, and then you can go find them in your own laws. So here I'm on page 31. The Texas Property Code provides that when a person fails to record his or her interest in property, that interest is void as to a creditor or to a subsequent purchaser for a valuable consideration without notice. To me, that's a duh statement. Of course it is.
Yeah, it is.
Yes, duh. And Texas law, now I'm on page 33, permits a plaintiff to seek recovery under a theory of unjust enrichment when a party has obtained a benefit from the plaintiff by fraud, duress, or the taking of an undue advantage, or when a person wrongfully secures or passively receives a benefit which it would be unconscionable to retain. Oh my goodness, that is so fabulous. Because that's exactly what they have done to millions and millions and millions of people, and in the process have ruined our economy and taken our homes and our down payments and ruined the values. It's an economic devastation that we have received, the people have received, particularly in this country, but other countries too. I mean, look at Iceland. And the fact is, it's been unjust enrichment. And they knew exactly what they were doing. So this, let's finish these rulings and reading through this judge's ruling, and then I've got some questions of you, James. We've been sort of talking about it as we go. How can people use this? What can they do? And here on page 34, I love this. James highlighted this for us. The MERS system, however, allegedly goes beyond the limited function of being as a nominee by usurping the role of the county as a public registry of real property interests. MERS is not a public registry, but a confidential electronic registry of mortgages available to lenders, servicers, and other players in the mortgage industry to track the ownership and servicing rights for mortgages traded amongst MERS members. And of course, the whole point of our recording statutes in the law, like the next paragraph that's not highlighted goes on and says, it's to protect the purchasers and creditors against prior interests in real property. So when MERS has usurped this public record, we have nothing to rely on. And that is so true. There's so many people, I know from personal experience, they say, oh, help me, I have stopped paying my loan, but how can I make sure I don't get foreclosed? And the issue is nothing has been recorded on their property. The MERS foreclosure mill machine only records ownership just before, like seconds before they file a notice of default. So that it is totally, you don't even know who your lender is. Yes, and based on the allegations set forth, one could plausibly infer that defendants obtained a benefit from plaintiff, remember the plaintiff's the county, through fraud and or by taking undue advantage of the county's policies regarding recording property liens, and that in order to confer upon its members the benefits of perfected lien holder status. This judge really does get it. And
Yes.
You, James, have been involved in these pleadings, right, over these past however long it's been. How long has this been?
I will never admit that I have direct involvement.
Okay, he's never had no direct involvement.
But I'm certain that I would say a lot of my writings are now being copy and pasted or if nothing else, plagiarized.
Right.
It just took years.
Well, like I think my mom used to say, the wheels of justice grind, but they grind slowly. And so the conclusion, for the reasons set forth, defendant's motion to dismiss is denied. The court concludes that plaintiff alleged sufficient facts to give rise to a plausible inference of liability with regard to plaintiff's causes of action regarding the violations of these sections, unjust enrichment, and fraudulent misrepresentation. The court retains these causes of action. So, now, this is a 14-day order? How long does the plaintiff...
No, the 14 days is the time frame for the county to amend their conspiracy portion of it.
Okay. So this was the 3rd day of July, so that would be next Wednesday, a week from today.
I believe so.
So the county's, I'm sure, working hard on amending their...
Well, I'm not really worried about what the counties do. I'm more worried about what's going to happen to Joey Rodriguez, because that's the one that's going to shake the earth.
Right, because he's pro se, and he's gotten to the point where...
Well, he's asked one question. Do they have a right to title? Yes or no?
Exactly. Okay, so that is the key point. If they don't have the right to title, then they can't take the property.
Correct.
So when that order comes down and we're expecting it to be no, they do not have right to title, then what happens?
Then I would assume that every investor in the world is going to realize that if there was never a right, the investors in the world are going to have what all they needed, because they're not going to be able to, they're going to go beyond, well, you didn't tell us all the risk. You just sold us something that wasn't real.
Right. You claim to, yes, you claim to have title and you don't.
Yeah, I could say all hell and pandemonium breaking loose.
Okay, so this will throw chaos into it.
Yeah, and for all these idiots that want to go out and buy bullets, I'd suggest you buy rice and beans and feed your neighbor, or you're going to need them.
Exactly. Let's stock up on food to survive. I totally agree. So the investors are going to be doing more lawsuits against the banksters that put the mortgage-backed security trust together for lying to them.
And
right?
I will say this: Fannie Mae and Freddie Mac have a get out of jail card free. They got one sentence in both of their agreements to get them off the hook, so the taxpayer doesn't take that hit.
Oh, so what is that sentence?
Heck, if I remember what it is.
Okay, I'm making a note. I'm writing this right now. Have a sentence to get off the hook. So,
Well, it in essence says that the trustee and the underwriters have a duty to make sure that it conforms with statutory law. And if it doesn't, then it doesn't conform to Fannie and Freddie. So that takes them off the hook. They got a get out of jail card.
okay, so here's the next question. Assuming that, push is coming to shove, because I think this is what we're basically saying right now. Push is coming to shove, and we're going to have a federal ruling that the banks do not have right to title, which raises the question about all of the foreclosures that are already done. Right? So we have, what about those done?
Well, I think that would boil down to each individual person as to what they want to do, and I could see that being an attorney's field day for profit generation.
Right, right. For either monetary damages or get the property back.
Yeah, and I'm not going to specify which one, because some states allow redemption, some states don't. But if it was a void order, then it couldn't have been sold. But do the redemption laws come into play? I wouldn't want to call that ball.
Right. Okay, so that's the next thing we're going to have to find out. That would be very helpful to know, is which states allow redemption, which don't. How can owners proceed? Because we've got...
I wouldn't worry about it. I just let the people find out on their own. They'll find out real quick.
Yes, but you know, if some people do the research and then we can just blast it out so that everybody can benefit from that, why duplicate millions of times the same research? That's my goal, is to really do it yourself, get your house back, and understand what is required. And if it requires an attorney, then that's my next goal, to round up 1 million attorneys, because everyone needs gonna have 40 clients. There's 40 million people, I swear, that are gonna go after these banksters. Now, here's the next question, James, and this is what I've been saying from the beginning. And we've already talked and mentioned today that the banks may go out of business or be absorbed by other banksters who may change their decision here shortly. If Fannie and Freddie are off the hook because this does not conform to statutory law, then how does from whom does an owner get any monetary damages if all the banks are bankrupt and gone?
Hey, I would have to say first come, first serve.
Oh my goodness. Oh my goodness. See, and another idea that I've had is a concept is that the banks, Fannie and Freddie, they have vacant foreclosures on the books. They've got millions of these vacant homes that they have not listed, have not sold, and I believe still have not sold them to hedge funds. So here's a question, James. You said if it's been sold to a person, what if it was sold to a hedge fund on a REO to rental scheme?
Still going to fall under the state's redemption and each person's own actions as to what they do.
Right, right. Well, I have predicted from the beginning that this is going to be, if and when the people could finally get some justice and rulings upon which we could depend to unravel this fraudulent securitization Ponzi scheme, that it would be chaotic. It would be completely chaotic.
Yeah. I mean, I look at it this way. For a lot of times, sometimes it's better to count your bags of rice and beans and move on, because you're going to be hungry.
And why do you say that, James? Clarify.
I could see it coming.
Yeah. Yeah.
I mean, we're going to go back to tangible values of this world, and too many people are living off the intangible values and beliefs, and I see that's fixing to become a problem.
Yes, yes. And in fact, I think Monday I had the emergency alert, Federal Reserve might just shut their doors. They've been talking about it. And if you look at from the bankster's viewpoint, how much chaos that would create, that would be a perfect thing for them to do, because it would throw the entire planet into total chaos and literally completely disrupt the way of life as we have come to know it.
Well, it takes us back down to tangible values to where
Right.
you work 8 hours a day, 40 hours a week for your beans and potatoes.
Right.
And you don't sit there and pay somebody 5 baskets of potatoes the right to work.
Yes, yes. This is truly. It's fascinating to me that it feels like it's coming together many different aspects of all the tyranny. We've got almost there a breakthrough decision, shifting the tide that will greatly shift the tide in favor of the owners in keeping their houses, in getting restitution of their houses back, in stopping the foreclosures. It's truly amazing. So we thank you so much, James, for bringing this to our attention. Is there anything else you want to leave us with?
No, that'll do. Everybody will have to reach their own sources in life.
Now, here's the Hibernia. This is what you were talking about earlier. You mentioned Hibernia. This was in April 1988. And what did you? What was the point you were making about this?
The federal Fifth Court of Appeals didn't give a damn what the bank's customs were when statutory laws governed.
Right.
And statutory laws, and that happened to be the Uniform Commercial Code.
Right. Right. Just because you have commercial custom doesn't mean a thing. It's just exactly like what we've seen. I've talked about it earlier that I've been involved, for example, in real estate for a long time. And when I first got involved, what escrow did at that time on a transaction is quite different than what they do now. And I've even seen this quoted in, I played a video, golly, it was from a bank attorney and another attorney. They were fighting, arguing in court on appeals. And the bank's attorney got up and said, well, Your Honor, this is just how it is. This is what we've been doing, arguing custom. Now that makes it more clear. And the judges are going, just because it's custom doesn't mean it's legal. Yeah, no kidding. No kidding. Wow. Well, James, we're going to have to say goodbye for today. We thank you so much for sharing this with us. We thank you so much for your decade of fighting. Please, as soon as you know about the order for Joey Rodriguez, please let us know.
You'll be the first on the list.
Thank you. And as usual, everybody, we are now dedicated to bugging the banksters and the politicians and the bureaucrats, because truly we must get our country back and start with keeping our homes. Homes are number one. We'll see you tomorrow.
Goodbye.
Bye, James. Thanks.
But it's always the same old story. The rich reign supreme while the poor can but dream under Labour or Liberal or Tory. And I say, bugger the bankers and politicians, bugger the bureaucrats too, bugger the buggers who make up the rules. And if you're one of them, bugger you. And if you're one of them, bugger you.
The system is bent and the money's all spent. We're battered from every direction. The workers get taxed while the wealthy relax.
With nary a moment's reflection. When it's brass, there's muck, and they don't give an arse, 'cause we're programmed against insurrection. And I say, bugger the bankers and politicians, bugger the bureaucrats too, bugger the buggers who give up the struggle for justice. But I've done my time on the protesters' line, and these days I show my dissent by loitering within my tent.